So we're really looking forward to a wonderful conversation about an important and elusively accessible topic, which is much harder than it seems. So if you have not read this wonderful book, I really recommend it to you. Bill Araiza's Animus. I didn't really have to look at it to know the name, but Animus. It is an elegant, slim volume, one of those law books that comes around every so often, like Grant Gilmore's Ages of American Law or Chief Judge Katzmann's Judging Statutes, that in a spare volume teaches and provokes you in very important ways. It's really remarkable. And, you know, Bill, our friend and colleague, is a good guy. We all know that. But he's a great scholar and a terrific writer, and he's put it all into this book. Now, this book builds on his years and previous work, on equality. And so it just doesn't, leap out of a sudden. It's really probably, I don't know how old Bill is, I don't want to know. But if you asked him how long did it take him to write this book, he'd probably say, 5 decades, something like that. It's a really terrific book. So the topic is Animus. We've got a panel that is going to do a terrific job. This is a topic that is very much in the news and timely in very meaningful ways. I mean, you only have to think of some of the recent cases. And also the daily news about the Trump administration's policies and how we feel about them. His policies, his travel ban, his immigration orders definitely reflect inherent dislike for particular groups, which is what the definition of animus is. And recently a case law, including Master Cake Bakery, that case, which involved, animus to both the fundamentalist conservative bakers and also animus towards certainly the gay customers. So it's something that's very much in the lexicon. Now, for a couple of decades, the court has been using animus in equality cases, equal rights cases, but this book takes it all the way back to the framers, the founders, and their discussion of factions, which is a word we all know. If you ask yourself, is the word animus in the Constitution, you're probably not going to find it. Unless it's after the reception, you've had one too many, you're probably not going to find it. But it goes on back, and then it traces the development of this concept all the way up to the more recent cases, the same-sex cases, DOMA cases, Windsor, United States versus Windsor, and Obergefell, which I can never pronounce, versus Hodges. And so it's got that span. But tonight they're going to be addressing a number of questions, and I think having you be able to witness this dialogue about, not only what does it mean, but why is it important, why is it more important than ever before? Is it actually a useful jurisprudential concept? I mean, how do you apply it in practice? How do you uncover animus? What do you do about it? When is it acceptable? When is it not acceptable? All of these questions will be before you tonight. So with that, I'm going to ask Bill to take over this hugely expert panel and begin an evening that I'm sure will get you thinking for a long time. Thank you all very much. And thanks, Bill, for this wonderful book.
Thanks, Nick. I really much appreciate that very, very, very kind introduction. In particular, I appreciate the description of the book is short for some reason. For some reason, that's always come easily for me. Before I introduce the book, let me talk a little bit about how I hope the evening will go. So I will again introduce the book, hopefully as short as I can be. And don't underestimate that. And then we'll have some brief responses and kind of initial thoughts from members of the panel, who I'll introduce in just a second. But I very much want this to be an interactive event, so I absolutely ask for and encourage people to participate. We have a couple of cordless mics up at the front, and if anyone, after the panel comes up with their original thoughts or offers their original thoughts, if anyone wants to weigh in on the conversation, by all means, just raise your hand, and either I or someone else will walk a mic over to you. Okay, so so I was asked to sort of talk a little bit about how the book came about and what the book is all about, and I'll do my best to do that in as quick a time frame as I can manage. So you know, this is not the first book I've written, the first academic monograph that I've written. I instead wrote a previous book on Congress's powers to enforce the 14th Amendment. And in the course of doing the writing and the researching and the thinking about that book, I started to encounter something odd, something that eventually led me to start thinking about the animus concept that eventually became the subject matter of the book. What I found was that when the court considered legislation enforcing the 14th Amendment, its review would often turn heavily on the suspect class status of the group that was being benefited by the legislation in question. So, for example, enforcement legislation that sought to benefit women's equality was reviewed relatively deferentially because sex is a suspect or quasi-suspect classification under the Equal Protection Clause. By contrast, enforcement legislation aimed at the equal protection rights of the disabled, that sort of legislation was reviewed much more stringently exactly because disability was not a suspect classification under the Equal Protection Clause. And this struck me as odd because courts have recognized that discrimination against non-suspect classes, like, for example, the disabled, or more recently against gays and lesbians, can in fact violate the Equal Protection Clause even in the absence of that group being denominated a suspect or a quasi-suspect class. In other words, it was possible for discrimination to be struck down as unconstitutional even without that kind of suspect class analysis that the court was engaging in all of these enforcement power cases. So that led me to start thinking about those cases and the seeming oddity of discrimination being struck down even in the absence of the court's recognition that this is the kind of discrimination that normally leads to heightened review because it's a suspect class. So that kind of oddity eventually led me to start thinking about animus. Now, I had to get the Equal Protection Enforcement Power book out of the way. I did. What followed was the prototypical funny story, which is I was invited by my publisher to go to lunch at the annual conference of law professors. It was that year held in Washington. I expected this lunch to be a quick, congratulatory, well done, let me buy you lunch kind of event. And halfway through the appetizer, my publisher, turned to me and said, "So what are you going to write for us next?" And I was a little bit taken aback because I wasn't expecting that question. And I said, well, you know, I've been thinking about this idea of animus. It, had kind of come to mind while I was researching and writing the book that now you've published. And maybe that's kind of what I want to think about next. She said, sounds interesting, let's do it. And so before even the main course had arrived, we had reached a deal that I would write, and then they would publish this book about animus. So what's the book about? Well, the book really is about this concept of animus, this kind of deeply foundational idea in American law that a legislative purpose that does not look toward the public good, but that instead looks purely toward as Nick said, a faction's private regarding interest is almost per se not a legitimate use of the legislative power. It's almost per se unconstitutional. That's deeply resonant. On the other hand, as I found out when starting to do the research, figuring out what a public purpose is or what a public purpose might have been in the legislature's mind as opposed to a private regarding purpose was really a very, very difficult enterprise. So that really became sort of the task of the book, is figuring out when, in fact, does legislation or should legislation be thought of as pursuing a purely private end, in this case the end of dislike or mere disapproval of a group, and when contrarily a law should be thought of as promoting a public interest. My argument, which if you read the book, which I urge you to do, is that animus is a constitutional wrong in and of itself. No ifs, ands, or buts. It is not a trigger to some type of heightened scrutiny that might or might not lead to the laws being struck down. If a court concludes that a law is grounded in animus, that should be the end of the game. The law ought to be struck down. Indeed, in that sense, the book argues that animus ought to be understood as the modern version or the modern instantiation of an old 19th century concept, one called class legislation. Now, in his introduction, Nick talked about the problem of faction, that if you've read the Federalist Papers or understand what the Federalists, in particular Madison, were talking about, you might have a sense of. Class legislation, a concept that developed in the 19th century, was sort of the next step in our jurisprudential thinking about this problem of laws that don't aim toward the public interest, but instead only aim at promoting a goal. The idea of class legislation, fundamentally, is that legislation that pursues the interest of one particular class rather than the public as a whole is, no ifs, ands, or buts about it, unconstitutional, not an appropriate use of the legislative power. I argue that animus-based laws in the 20th and 21st century are merely the modern version of that same type of class legislation that courts, first state and then ultimately federal after the 14th Amendment, unanimously condemned as violating the, really not just the 14th Amendment, but the whole idea of republican government, that is to say, government that acts for the public good rather than the private good. So, fair enough, we can understand in a very intuitive way that legislation promoting private ends is in fact deeply problematic, in fact ought to be struck down as unconstitutional, but that just raises the problem of how to find animus. So what I argue then is that the court has used or has employed a number of common sense factors in an analogous, although not perfectly alike context, and that those factors might in fact help us with the very difficult task of uncovering animus, of determining when a law really does promote a private interest and not a public one. Where do those factors come from? Well, they come from the court's 14th Amendment jurisprudence. They come in particular from the jurisprudence that seeks to determine when a law has a discriminatory intent. Now, the term discriminatory intent might strike you as exactly the same as animus, and that's almost right. It is a close cousin to animus, discriminatory intent is, but it's not the exact same thing. And so what I do in the book is I try to explain how discriminatory intent is related to animus and the inquiry that uncovers animus, but it's not the same thing, and how it differs in important ways. And maybe we can talk about that either during the comments or during the Q&A. Now, the intent requirement often gets a lot of bad press, especially among legal academics, and maybe for good reason. In particular, the intent requirement has been used in recent decades to make it very difficult for plaintiffs to challenge legislation that, even though there's no explicit intent to discriminate on the basis of race, nevertheless reflects a sort of racial hierarchy that really is deeply problematic. So the intent requirement has kind of stood in the way of these very needed reforms that plaintiffs have been trying to push through the courts. I get that, and my argument does not require that one adopt the discriminatory intent idea wholesale, certainly not in the context of race discrimination, but in the narrow but important context of animus arguments, I do believe that the factors the courts identified as part of discriminatory intent analysis can in fact be quite useful in the task of uncovering animus. The details are in the book, but I hope that this brief sketch gives you a sense of what the book is all about. Structurally, the book begins in the first half by looking at all the court's modern animus cases, highly under-theorized cases which do not provide a comprehensive theory of animus, but that all provide little clues or threads, if you will, that I then, in the second half of the book, try to pull together in weaving a coherent animus doctrine that makes sense. So the first part of the book is about the cases. The second part of the book kind of tries to harmonize and explain the cases in weaving this more coherent theory. The last thing I'll say before I sit down and turn the podium, so to speak, over to my friends and colleagues, is that, as Nick alluded to in his introduction, Animus now, today, goes a lot farther than simple concerns about equality, than simple concerns about equal protection. As I was talking to Sabeel before we started out here, he complimented me on writing a book that really is deeply timely, deeply topical, and I responded, well, you know, it's just a matter of dumb luck, and sometimes, as he said, it's better to be lucky than to be good. I don't necessarily think it's a good or a lucky thing that we have to be thinking about animus all across the world that we live in, but unfortunately we do. In a world of increasing, reheating cultural conflict, in a world of increasing xenophobia, in a world of really deep cultural anxiety, disapproval of groups is on the rise, and that's simply impossible to deny. And so, like it or not, lucky or not, we're stuck with a world, at least for the time being, in which we need to talk about animus, what it means, how to find it, what we should do about it, and that's really what this book and what this conversation tonight is all about. So, with that in mind, I'll very quickly introduce my friends and colleagues at the podium, ask them to speak just a few minutes each, and then we'll have hopefully an overall conversation over the course of the next hour or so. So I believe we're going to begin with Joel Gora, who is off on your right side, who teaches First Amendment law and constitutional law here and has done so for a very long time. We'll then move on to Donnie Gewurtzman, who is a professor from New York Law School, who is teaching a constitutional law class here this semester. And Donnie and I have known each other for many years now, and it's really great to have him here at the school and here tonight. Third up will be Susan Herman, who also teaches constitutional law and criminal procedure here, and of course also, it's kind of in her off hours, is the president of the ACLU. And finally, and certainly not least, is Sabeel Rahman, one of our newest professors here at the law school, who does wonderful work on law and economic equality, and delighted to have him as a commenter as well. So having said all that, let me turn the podium over to Joel, and ask him to fire away.
Well, congratulations, Bill, for writing this wonderful, elegant book. That was the first word in my notes, too. I'm not stealing from the dean. But I would certainly second the dean's wonderful description of the book and his prediction of the impact of the book. And I also want to thank you, as a professor who teaches equal protection as part of constitutional law, for all that I learned from this slim, elegant volume. It really confirms my sense that you have an uncanny ability as a legal analyst to take deep dives into cases and doctrine, sort of unpack them and repackage them in a different and better way. And it's, I'm so envious of your ability to do that, and so appreciative of your having done it for equal protection. So congratulations and thank you. But it's also caused me a bit of a problem. The newer conceptions that you've helped me understand. What I do each year when I teach constitutional law, and I see many of my former and present students here, I'm so glad to see you, is after we spend about 8 or 9 class sessions on equal protection with its complex hierarchy of different tiers of review. I do a chart. I created a chart, a little one-page chart. I didn't bring copies. Sorry. And the name, I put a little title on the chart, trying to be a little jestful. The chart is called Cheers or Jeers for Tears, T-I-E-R-S. And in the chart, I list the categories of review: strict scrutiny, what triggers it, what the test means in terms of the formula, and then the areas in which it's used, race and ethnicity, certain alienage, certain voting cases, some access to the court's cases. And then we have intermediate scrutiny. This is all familiar to people who have studied this, right? The formula and the areas in which it's used, gender or sex discrimination, certain forms of alienage, illegitimacy, and sexual orientation with a question mark. Because I'm not exactly sure when I work on this chart exactly in which tier I would put the review of discrimination based on sexual orientation. And then the bottom tier is actually 3 tiers. Again, this is familiar to con law students. It's the rational basis tier. And I tell my students that it has 3 tiers. There's basement level rational basis, which is the back of the hand. You get almost no review of your claim that the categories which burden you and benefit others are not rational or not reasonable or make no sense. Back of the hand, basement review. Then there's lobby level rational basis review, where you get a bit of a hearing and the justices pay some attention to your arguments, but you ultimately lose the case because in the rational basis level of review, the burden is on the challenger to show that the classification is unreasonable, and that's a hard test to meet. But then I said there's mezzanine level rational basis review, and that's where you get a closer look from the court at why these classifications are made. What's the point of them? Do they make sense? And the less they make sense, the more there might be other reasons for them, which gets us into the area where we might start looking at animus. And in that area, I suggest that the types of cases where the court gives mezzanine level rational basis review are cases where there is, quote, animus, unquote. And where the groups being disadvantaged by the classifications or being burdened by the classifications are groups that are similar to the discrete and insular minorities that were characterized in the famous footnote 4 of Caroline Product's case. Footnote. One of my constitutional law professors was the person who, as a law clerk to Chief Justice Stone, drafted footnote 4. So how's that for legal trivia? In any event, so the problem that you've caused me, Bill, with your elegant book is I had animus down in the mezzanine level of rational basis review, but you've convinced me that it is such a powerful tool of equal protection analysis that at the very least it ought to be under strict scrutiny. But now I really think it has its own tier at the very top. Because as you point out, once that kind of animus that you're trying to sharpen the tools to identify and to deal with is determined, that's it. It's even more powerful. It's like Super Pac-Man. It's even more powerful than strict scrutiny. Because as you correctly and carefully point out, with strict scrutiny, the government still has an opportunity to try to show a compelling justification. With animus, game over. And so I'm going to redo my chart, put animus at the very top with my thanks for giving me that appreciation.
Happy to do it. So Bill, thanks so much for having me. And this is a fascinating and worthy and ambitious project and an incredibly accessible and well-written book. So in thinking about what I was going to say, the question I want to answer is whether we would have been better off if you had never written this book at all. And the conclusion I came is that I personally am better off, but the United States Supreme Court probably isn't. And I want to sort of see if I can get there. So this line of cases, the animus cases, specifically Claiborne, Moreno, Romer, this is one of the areas of con law that I hate teaching. And the reason I hate it is that it's nearly impossible to reconcile these cases with existing precedent on rational basis scrutiny. It requires us to close our eyes to cases like FCC v. Beach Communications and Railway Express and Beezer, these cases that define rational basis scrutiny as being very deferential. The court doesn't do us the favor that Joel did of using words like mezzanine level scrutiny. It basically has one word to describe all of this, rational basis scrutiny. And if you're going to make sense of these cases, you have to pretend that these other precedents somehow don't exist. This frustrates students. It frustrates me. I'm guessing it frustrates federal judges that actually have to put this doctrine into action. So I personally am very thankful for an effort to theorize all of this and try to make it coherent. It's funny, when I think about these cases, I tend to almost treat them as part of a larger political effort by the court to smooth out the rough edges of American pluralism. The idea being that we live in this very contentious society, and if you want to use your faction to hurt another faction within the society, at least don't say anything overt that invokes fear and disgust, right? If you're going to do it, let's sort of keep our pluralism kind of nice and polite. So this is a terrific and much needed project to try to come up with an underlying theory for this line of cases I hate teaching. Where I start getting worried is that you've chosen to ground this stabilizing effort on an unstable concept, specifically class legislation. And this is where I start getting worried, and I worry if I'm the Supreme Court, I start worrying that wishing you hadn't written this book. So the court went through this period where it saw itself, right, as an institutional safeguard against class legislation, that it was going to get in there and prevent one faction from using coercive government power in ways that hurt another faction, where it demanded that government come up with some rationale that what it was doing was based in the common interest and not an effort by haves to hurt have-nots or have-nots to get back at haves. And as you remember, this ends with a terrific disaster from the court's perspective in 1937, right? Roosevelt attempts to pack the court backs down. Legal historians in the room can take issue with some of the claims I'm making, but this is sort of the conventional story. And the way the court resolves this to make sure this attack on its legitimacy never happens again is it adopts this very deferential form of rational basis scrutiny, specifically because it wants to get out of the business of policing the branch's use of class legislation. So into all of this, you walk in. And I worry that what you're trying to do here is not trying to rehabilitate the Animus cases to make me feel more comfortable with them. I'm worried you're trying to rehabilitate the Lochner era. And you're doing it really quietly, right? You're titling your book Animus, you're drawing everybody's attention away from it. I think that might be your secret agenda. And if I'm the court, I start getting really worried about this. Because all of a sudden, you're sort of threatening to reawaken the specter of the court having to discern when we've got impermissible class legislation that caused a disaster the last time the court tried to do this. So then I started wondering, well, maybe we're better off leaving this area untheorized. Maybe we're better off leaving this like strand of Animus cases the way we treat like rogue strands of common law doctrine, as like kind of a nice case-by-case area where the court can experiment and sort of invoke where it wants without having to use words like class legislation that start getting folks that worry about the court's institutional legitimacy really worried. So those were my thoughts. I want to thank you again for such a well-written and provocative book, and that obviously really made me think a lot. And I personally am glad you wrote it.
Well, I'm glad you wrote it too. There are a lot of things, before getting to the substance, here are some of the many things I admired. The punchy title, although I want to know what the spider is doing on top of it. So when we get to questions, you can explain that spider, because it's right there on top of the U. The other thing that I really liked, and this again before the substance, is that in the acknowledgments, we all know that in addition to thanking our professional mentors, the people who taught us constitutional law and all, we should thank our families because they put up with our writing the books and they were part of it. But one of the things that Bill does in his acknowledgement, which to me is so much about the spirit of the whole book, is he thanks his students. Mm-hmm. And I think we sometimes let it go without saying that it is by being in dialogue with our students that we become inspired and that we think the thoughts that we have. So the fact that you brought that out, I think is just, to me, I love it. Plus the tone of the whole book is the tone of a teacher. Did you know, as you go along reading the book, Bill frequently says, now to recap that, or to summarize, or now you may recall, and he's clear, it's himself as a teacher as well as a scholar. So I think I'm going to agree with Donnie's bottom line that I'm glad that Bill wrote this book, but what I want to say is that what's amazing to me is that he thought to write it. So for years I've been teaching these cases in equal protection, and they're annoying because they don't fit. But here was my take on amicus. Amicus pops up in cases where justices, either conservative or moderate justices like Anthony Kennedy, don't want to say where they are on Joel's chart. They don't want to apply the suspect classification doctrine. They just don't want to do it. So 2 examples. Claiborne, you talk about a lot. Justice Marshall, in his opinion, says, we should have declared that people of very low intellectual ability are a suspect class. Look, you know, they're discriminated against. There's a history of discrimination. The majority opinion doesn't want to go there. It just says, oh, there was animus here, you know, and just end run, ad hoc end run around the suspect classification doctrine. The LGBT cases, everything Kennedy's ever written, Lawrence, Romer, Obergefell, Windsor, again and again, he's talking about discrimination of all sorts and exclusion of all sorts without ever saying, you know, the question mark, how to answer the question mark on Joel's chart, even though the lower courts have been struggling with this for years. So what the animus mentions seemed to me to be were ad hoc and end run. And frankly, I'm still not convinced that there was an amicus doctrine there. I think you created it. I think you took all these little threads that didn't really altogether hang together, and rather than discovering the theory, I think you've woven a theory of how this might make sense. So the vision, it never would have occurred to me that this book needed to be written, that somebody needed to look at what's all this talk about animus? Is there actually a theory behind it? And what Bill's book does is it talks about what really could be the theory behind it. So I think that in terms of whether the Supreme Court would like this, I think they actually would like this, you know, fears of Lochner aside. Because it's never been surprising to me that justices like Kennedy and the more conservative justices don't like the suspect classification doctrine. They stay away from it. They don't like it. And I think among the things that they don't like is that it sounds in identity politics. Yeah, you're going to get special judicial solicitude because of your group and because of the history of what's happened to that group. Not only is it identity politics, it's judicial affirmative action, right? You think about that. You know, Kennedy doesn't like affirmative action. So it's not surprising to me that a number of justices have been avoiding Joel's chart. You know, they don't disagree about racial discrimination getting special review, but they just don't want to say whether they're willing to go any further. It seems to me with the turn of having, you know, Justice Gorsuch as our latest justice, unless something really radical changes in the presidency and the court, we're going to continue to have conservative justices who are not going to agree with Thurgood Marshall. And therefore, it seems to me they will be extremely grateful to be told that what I think used to be ad hoc evasion is a theory. And you know, maybe they're going to agree with the way you've spelled out the theory, maybe they won't. But I think it gives them a kind of legitimacy to what they're doing. Now, in some ways that's good, because you know, why should only some groups have the right not to be treated with animus? Yeah, every individual should have the right to be treated with dignity. And that's a lot of the message that you get out of Obergefell. You know, it shouldn't only be about what group you belong to. It should be, you know, nobody should be treated with animus and hatred. So, you know, in some ways, this is a broader, both broader and narrower than the suspect classification doctrine. So, and I think I have to get to my but. You were saying before that, you know, a lot of academics don't like the intent requirement, which, you know, overlaps a lot with the idea of animus, the idea that we're looking to the mens rea in some way to say what's right and what's wrong. And what I don't like about it is that even though, you know, I think you could argue about whether it is or isn't a better alternative to the suspect classification doctrine, but it moves us further down the path of Washington versus Davis and the idea that government has no obligations. All they have to do is not purposely act with hatred. And to me, Washington versus Davis, which says if you discover that you have this personnel test that is causing you not to hire, you know, African Americans as policemen, it's okay as long as you didn't purposely discriminate against them. You have no obligation. Alabama never had any obligation to prosecute people who were, you know, killing, you know, anybody who was black. The felon disenfranchisement laws, even though they have an incredibly disparate impact on people on the basis of race, well, you know, but it's for a neutral reason. It's a race-neutral reason because we just think we want to punish people who've committed felonies. So, you know, I think you've made a lot of sense, probably more sense than it deserves, out of the Supreme Court's mention of animus, and you've really forged a doctrine out of it. But I'm not sure, you know, whether ultimately, my concern is very different from Donnie's, is that it's kind of locking us in to the idea that we're looking for something that's almost like, you know, purpose or criminal intent before we can condemn governmental action. Now, I know you're working with Washington versus Davis because that's what you have, and I don't think you're particularly, you know, looking to endorse it. But I do think we're kind of moving in that direction. One more comment on what I think is interesting about this in terms of this time. Over the years, I'm sure, you know, you've been part of these discussions as I have, LGBT advocates have struggled with the question of whether to claim suspect, you know, classification status. You know, do you want to claim victimhood? Do you want to, you know, claim, you know, lack of political power? And how do you want to position yourself there? So the end run, again, might be useful not only to Supreme Court justices who don't like the suspect classification doctrine, but to the people who are advocates for the disabled, people with disabilities, for the LGBT people, to not have to, again, figure out where do I want to be on Joel's chart. But I think maybe there's an additional answer here of some bigger equal protection doctrine that is not only about animus and that's not only about suspect classification doctrine. The final thing I want to say is one other place where I thought that I could just see your generous spirit is that you were trying to weave together things in a way that accepts all cases and explains them, and sometimes explains them away, like the Lofton case of two gay men can't adopt a child because. Bill says, well, anachronistic. At the time, people thought it was in the best interest of the child. And I just thought there was something rather wonderful about the fact that you weren't finding any of the cases there to be inconsistent with each other or wrong. So at the end of the day, I was so touched by the generosity of spirit here, added to your incisive mind and to just the soul of the teacher and scholar. So I just think it's a wonderful book. Congratulations.
Thank you.
So, Bill, I'll add my congratulations and thanks for this book, and I'll say I find myself a bit in the position of your editor at the lunch, where I kind of wanted, my main question for you is kind of, well, where's the sequel, and when can we expect it? And I'll come back to that, because I think this really is the book of the moment in a lot of ways. So, when I was reading this book, I had the same reaction as the other panelists, right? This is the educator par excellence speaking through this book. But I think I think about the sort of the audience that is being educated, right? Not just us and law students and us in the law school, but the thousands, millions of people who have now found themselves engaged and moonlighting as constitutional law scholars and protesters, right? And I'm thinking about things like the travel ban litigation, the trans ban. These are all about animus, and so I'll come back to that because I think you raised some sort of forward-looking questions rather than backward-looking on how this reconciles with the doctrine. But a way to set that up is, so I think that I share some of the class legislation worries, right, that the other panelists have raised. And the problem, of course, is in the Lochner era, if organized labor is a class, a faction, then legislation supporting that faction is impermissible. And how do we have the good animus as opposed to the bad animus doctrine? I think you have an answer to that. But I think part of it is that your argument strikes me as being rooted in a sort of deep optimism, which I share, actually, right? A deep optimism about the value of equality and the notion that we, in fact, can come to common agreement about what it really means to be treated with animus and what it really means to be treated as a full and included member in the community. And so I want to raise maybe a couple of just quick questions, and you can kind of pick up with them as you like. So the first is, going back to Lochner, is this an argument more for the Harlan dissent in Lochner as opposed to the Holmes dissent, right? So Holmes says the Lochner decision is wrong, and the court just shouldn't be in the business at all of messing with economic legislation. But Harlan dissents too, right? And he says, well, actually, we should be in this business, but we got it wrong on the facts. This is just on the facts, not a class legislation case. It's not problematic animus here. He didn't use that term, of course. So, if Harlan was right that we can make these judgments, then that opens up some more options. Then the second question here, I think, picks up where Susan left off. Is the book is animus, but in a way, it's also about the dignity idea in Obergefell and Windsor. And what are the substantive ideas of equality as opposed to exclusion that might be kind of lurking underneath in your theory, and that might maybe help us separate the good animus from the bad animus doctrine. And then the last question is, if there is animus, how do we cure it? When does it go away? And this is, of course, a central question in the travel ban litigation. We have travel ban 1.0, 2.0, 3.0. At what point does the taint of animus go away, if ever? These are all sort of questions like lurking in the book. They're questions for the sequel. And maybe I'll close my comment with just inviting you or asking you to sort of, if you could tease us with your thoughts for what comes after this book.
Great. Okay. So thanks to all of you for these wonderful comments. It's really so awfully helpful, and just deep, and I'm really, really grateful for them. Let me just, so what I'd like to do, I think, is maybe to just give a few reactions. If there are any other replies, then we can do those, or if people want to start participating, we can do that as well. Joel, with regard to your chart, I'm sorry for ruining your visual aid. Although I must say, over the course of my own teaching career, I have to say, I've gone through more visual aids than I care to admit, because I realized, I can't use that anymore because now I understand it better. And I think the idea with tiered scrutiny, and I think you alluded to this, is that it is in a lot of ways an unsatisfactory structure for equal protection. But of course, your suggestion of that, and your suggestion that animus kind of ought to be understood as now, help us, a new tier, right? Really kind of raises the deep question of, what's its replacement? And I don't just mean animus as a replacement, because I don't believe that animus can serve as a full-scale, all-purpose, comprehensive replacement for, the vast majority of equal protection doctrine, frankly, right? And I'll talk about race in just a minute and talk about how I don't think animus narrowly understood really can, in fact, substitute for a more affirmative, aggressive, race equality jurisprudence. But we have the problem, right? And there's no denying that that dissatisfaction with the tiered scrutiny structure with its mezzanines and basements and attics now, I guess, which is what animus would be the very highest level.
Peaks.
Peaks. The
Sounds
peak.
better than attic.
Fine, the peak of the house would, it just raises the question of what else do we do, right? And that actually brings me to Donnie. Because Donnie, you were talking about the bad ending for the class legislation story. And of course, you're absolutely right? So the 19th century is all about this attempt by courts to pierce the veil of legislation and to determine when, in fact, legislation is really, whatever the word really means, pursuing a public goal and when it is instead illegitimately pursuing a private interest. And as Donnie is absolutely correct in noting, that enterprise sort of, came to a very sad end in 1937 or 34 or wherever you want to exactly sort of note the date of its demise. But it did come to a bad end. But what's ironic, and this is, of course, what brings me back to Joel's comments, is that what replaced that structure was the tiered scrutiny structure. And it is so interesting, and for students, I hope you get the idea that when the class legislation structure ultimately collapsed, latest possible date, call it 1937, it was the very next year. Gee, what a not coincidence that Justice Stone starts experimenting in footnote 4 with what eventually becomes the tiered scrutiny that in a lot of ways ends up being kind of problematic. So as I was writing this and realizing this, I kind of found myself sort of in a loop. We start with class legislation. It comes to a bad end. We get to tiered scrutiny. That comes to a bad end. And indeed, another non-coincidence, the last time the court did a serious suspect class analysis was in the Claiborne case, where the court really sort of puts its foot to the gas with regard to thinking about animus. So it cycles. And I would hope that at some point we can break out of that cycle. But I completely recognize that we're really not there yet, right? And maybe, Sabeel, that's kind of one of the components of the next project is, where do we go from here? How do we break out of this cycle of continually readopting ideas that we've already known don't fully work, only to watch them re-fail yet again in a very predictable way? Rehabilitating Lochner. And this does get to the 19th century class legislation story, because what Donnie is really absolutely correctly cautioning me and us about is the risk that in aggressively searching for bad intent in legislation, we end up with verbiage like the verbiage from Lochner, We cannot shut our eyes to the idea or to the conclusion that this is a law with a definite end. That's not the exact language from Lochner, but is essentially a suspicion that really this is all about, Sabeel, the class of labor that captured the wheels of government and is now turning them for its own private benefit. And that is, of course, a great concern. And really, I think the proof is in the book, or it's not. And what I mean by that is either the book explains how one can avoid those shoals while still, allowing meaningful judicial scrutiny for things that, quote, really are based in animus, and when in fact it ultimately will always devolve back to whatever a judge thinks happens to be a private interest, and that the judge's class or sectarian interest may well prevail in the judge's thinking about what constitutes a private interest and what doesn't. So absolutely, that's a risk and that's a problem. So Susan, a couple of smaller points to begin with, and then kind of the deeper point about race. So the cover. I'd love to take credit for the cover, but I must tell you, when the book was being produced, and so NYU Press says, so what would you like in terms of the cover? I suggested to them what would have been the most god-awful, cramped, crowded cover that would have just repelled people rather than attracting people, which is, I think, what this does. I was really so delighted when I met the graphic designer from NYU Press, and he showed me this. I already knew about it, but I met him. I could say thank you, because that's a really great cover. If you haven't looked at it, buy it. Buy the book just for the cover. I mean, nothing else. It's really amazing graphic art. So that's small point number one. Small point number two, to recap as a teacher. So first of all, thank you for the very kind words. The idea of the audience really was the generalist expert. And by that I mean law students or lawyers who don't necessarily think about this 24 hours a day. And to the extent that that came through, I'm really, really delighted. I have to laugh. I think there was laughter, I think from some of my former students, when Susan mentioned the idea of recapping every so often, because I am, I guess by this time, notorious for doing a lot of recapping. And indeed, I remember one of my student evals some years ago where a student compared my class to a soap opera, which doesn't really advance very much from class to class because there's so much recovering of the ground from the previous episode. Yeah, you're right. It comes through even in the book, right? What can I say? That's why it's 220 pages rather than 206 pages, because there were 14 pages of recapping. On the deeper, more important points, though. So one interesting thing that I think Susan's comment kind of leads me to want to talk about very briefly. So Susan talked about the Claiborne case. Again, this is that very, very foundational 1985 case where in part one of the opinion, so to speak, the court holds that the intellectually disabled are not a suspect class. And then in part two of the opinion, so to speak, the court goes on and finds that this discrimination is nevertheless unconstitutional because it's based in animus. And for the longest time, I taught that case rather, as basically the court in part one basically getting close to a finding that the disabled were, in fact, the intellectually disabled were a quasi-suspect class, almost but not quite getting there, but then that near miss prompting the court in part two to ratchet up the rational basis review that it provides. And so I thought, you know what, one day I thought, I'm going to go down to DC. I'm going to go look at the justices' records on Claiborne, and I want to confirm that understanding. And as it turns out, the understanding is exactly wrong. That the second part of the opinion, the rational basis part, the animus part, was completely an afterthought. It was something that the justices kind of threw in really literally in the last couple of weeks of the 84-85 term. And that very interestingly, Justice Rehnquist, who is no one's friend of stringent rational basis review. He's very much in favor of extremely bargain basement rational basis review, right, to use your term, Joel. He said, let's just throw in the rational basis analysis after all, it's not going to mean anything. We decide hundreds of these rational basis cases, and no one's ever going to think it's important. As it turns out, he was exactly wrong. So not only was I wrong, he was wrong. But if you haven't had enough of my writing from the book, there was an article in the Penn Journal of Constitutional Law that recounts these justices' deliberations on Cleburne. Weaving the theory. So yes, I did actually weave the theory, and that was in fact my intent. And if I said anything different at the podium, I didn't mean to. The cases as they are very, very deeply under-theorized. The cases as they are basically are narrowly decided. They just sort of decide what they have to decide without really explaining in a more comprehensive sense what's going on. And so yes, I did in fact try to take those cases and I tried to weave a theory. And I appreciate the generosity point about Lofton. This was a case, this was a kind of a notorious case in gay rights circles where where the 11th Circuit upholds an adoption ban on same-sex couples. I did, in fact, try to incorporate Lofton into my analysis. It did, in fact, make me a little bit concerned. I made several copies of my gay card in case the other copies were going to be seized from me. But that's what I did. And call it generosity, call it over-focusing on trying to make everything fit together. And I think if I have a flaw among many as a scholar, that's probably one of them, is I just try too hard, right? I try too hard to make everything fit together when sometimes maybe the right thing to do is simply say, no, this just doesn't fit, and let's just sort of let's be explicit about that. So it's a very fair point. The largest point I want to make with regard to Susan, I'm sorry for taking so much time just chatting, is the idea of the intent requirement. And so Susan, I think, raises really, really important points about the problematic nature of the intent requirement. In our society as it exists, with this deep legacy of racism, to say that the only kind of race discrimination that matters is the kind that we can find as somehow being purposeful, really, in fact, blinds courts and puts roadblocks in front of plaintiffs, who want to sort of push toward a more comprehensive, affirmative theory of racial equality. And that's absolutely right. This is where I will not try to make everything fit together, because I don't think I need to fully embrace the intent requirement in order to use the intent factors as part of the animus inquiry. I think it's completely consistent to say, number one, under the 14th Amendment, race, and not just intentional race discrimination, but the whole structure of racial subordination was a primary concern of the drafters of the amendment. And if you believe that, you don't need the intent requirement. You shouldn't have the intent requirement with regard to race discrimination. But then I think you could also say, consistently with number one, number two, we need still to think about something like purpose, something like intent, when the subject changes away from race and toward types of discrimination that, for whatever reason, we are not willing to say that across the board merits heightened judicial concern. And I think that statement picks up a lot of the cases that are decided on an animus ground. And it seems to me that the only way to make sense of a theory that catches that unconstitutional conduct is to attach it to some notion of purpose or intent. It doesn't have to be subjective. Indeed, Chapter 6 says you don't need subjective intent, but there does, in fact, need to be some kind of underlying understanding of intent, right? Not comprehensively in the 14th Amendment, certainly not in race, maybe not in other areas as well. I think sex is an interesting question but I think you do need it for animus, or at least it seems to me. So Sabeel, the audience. So again, the audience, as I said a minute ago, the generalized, I'm sorry, I keep saying generalized, the generally educated layperson. And so to the extent that I was able to reach that audience, and to the extent you kind of saw that in the book, I'm really, really grateful for that. Yeah, so class legislation as a boogeyman. And the fear that, of course, is quite appropriate, as I said a minute ago, that a judge who doesn't like labor unions can simply say, oh, pro-labor legislation, that's just for the benefit of the private class of workers or of labor union members, and of course that's a problem. Of course that's a risk. But there is a baby in the bathwater, and I wouldn't want to throw out the baby of a real set of cases that really do reflect bad underlying motivations, along with the bathwater of judges sort of running rampant and just sort of making it up as they go along with regard to which classes, which kinds of laws really are class-based and which types of laws really are not. I think the challenge is really to figure out what is, hopefully, a foolproof, unlikely, but at least not a bad attempt to come up with a set of factors that in most cases will generally lead to a more or less accurate sense of when animus is really lurking. Sabeel asked, whose side are you on in the among the Lochner dissents, Harlan or Holmes? And I think it should be obvious I'm definitely on the Harlan side, because I think animus and the determination of class legislation or public-spirited legislation really is a fact-intensive inquiry. And I think we just sort of have to accept that. If we don't accept that, if we're on the Holmes side of the Holmes-Harlan debate in Lochner, then I think cases like Cleburne come out the other way. Then I think cases like Windsor and Romer come out the other way. All I need to do in order to maybe establish that point is to remind everyone of another case dealing with intellectual disability, a case called Buck versus Bell, where in the 1920s, the state of Virginia, in its infinite wisdom, decides that we're going to sterilize mentally retarded people. Because after all, as the court says, 3 generations of imbeciles is enough. It's Justice Holmes who writes that language. And if you are on the Holmes side of the Holmes-Harlan debate in Lochner, then I think you kind of have to accept the full ramifications of it. And I think the hopeful ramifications are you have to sign on to the opinion Buck versus Bell, right? Forward-looking, rather than just backward-looking, what's the next project, right? So yeah, look, I think it's a really interesting way you phrased it, that some sense of affirmative equality rather than just sort of negative, don't be bad people, don't be purposefully mean, maybe sort of is the next step in thinking about where an animus idea can go. I do think, Susan, that dignity in Obergefell gets us a lot of the way there, or at least part of the way there, that in thinking about everyone's right to dignity, regardless of the motivations behind the government that infringed on that right, maybe gets us more toward a vision of more, sort of more comprehensive equality. And I can easily foresee, although only in theory, frankly not in practice, I can easily, because of the politics that we live in today, I can easily see a judicial opinion that says the equal right to dignity that every American, which is every American's birthright, is infringed by structural inequality. And so, that kind of affirmative, non-purpose-based equality really, I think, is a goal. I think thinking about dignity and maybe coupling it to the animus idea, as I tried to do in my discussion of Obergefell in the book, I think maybe that's the next place where we ought to be thinking about, right? I think that's all I wanted to say. So unless folks here have replies, which I'm happy to entertain, maybe what we should do is we should see if anyone in the crowd wants to say anything. This looks like my class too.
I'm going to
We have a couple of hands.
Hi, thank you also for writing the book. I'm just curious, before law school I worked for a big corporation that was very active in supporting the marriage equality movement. And I'm just curious if you think corporations or labor unions or other big entities actually promote equality, or does their impact on these big public policy issues is that actually more indicative that they're a powerful faction that can actually be dangerous?
Well, again, I mean, I'll invite everyone here to chime in after I respond. I mean, look, I think they can be both, right? I mean, large corporations have large amounts of power. That power can be used for good or it can be used for ill. Indeed, when I was writing my book on congressional power to enforce the 14th Amendment, one of the things that I talk about is the importance of the court responding not just to their own suspect class analysis and, on that basis, either giving really skeptical review to enforcement legislation or really generous review, but in addition to responding to that suspect class analysis, enforcement legislation cases should kind of look more broadly and look to see what society is thinking about the appropriateness or legitimacy of certain types of discrimination. And in the book, the first book, the 14th Amendment enforcement book, what I say in particular is that entities like corporations and labor unions and universities and other civil society churches, other civil society organizations can really do a lot to change the conversation in a way that matters for itself, right? But also in a way that maybe should influence the court's thinking about the appropriateness of certain kinds of discrimination or the inappropriateness. And if it's the inappropriateness of certain kinds of discrimination, like for example, sexual orientation discrimination, maybe that ought to influence the court's decision to let Congress have more room when it enacts legislation that promotes LGBT rights. So, yes, there's a room for the good. There's also a room for the bad, right? And of course, corporations and other powerful entities can monopolize conversation in a way that we know all too well. I think that, I guess the sort of easy out, which is not really satisfactory at all, is that courts have to be judicious about what they hear or the lessons they take when they hear the conversations out in the public square. And maybe they have to be careful not to simply listen to the loudest speaker, but instead to try to listen to a more comprehensive group of speakers out in the public square. And if anyone else wants to jump in.
I would just add to that what you're saying, of course, is true, that it can be for good or for bad. But I think the good is not only if it affects the court. What you were saying about changing the conversation is so important. So we've had a few examples recently of big corporations really using their power, their economic power, for the good. So if you work with a big corporation, it's not just marriage equality, where a lot of companies were very valuable, but it's what all the companies and even the NBA have been doing when confronted with things like the bathroom bills, the transgender bathroom bills in places like North Carolina and Virginia. The fact that companies are saying, we're not going to come to your state unless you change this policy. Who cares if the courts are affected? That's going to change the policy because it's about the money. In the several of the travel ban cases, the one on the Ninth Circuit, there was an amicus brief that was written by large corporations from Apple to Sigma, down the line, like 100 of them, saying this is about our workers. We need, we can't look at things this way. It's tremendous power. And I've been talking to people in kind of more corporate contexts about, they often feel like, well, we have to be nonpartisan, we can't be political. And I want you to tell them that your company is doing the right thing. That they should be powers for the good, and whether or not the courts are listening.
Hey, Bill, rest of my colleagues, Donnie.
Hey,
great
Jody.
to see you.
Nice to see you too.
So, wonderful project. I especially like the idea that we all should be actively hunting for animus in legislation that is passed, state or federal level. It's an important project for all the reasons that Susan just described as well, that it's not just up to the courts, it's up to all of us to call it out. But returning to the issue of what the court's role is, the hunt for animus in legislation seems in conflict with the textualist approach to statutory interpretation. And I'm wondering, I'm afraid I haven't read the book yet, but I'm wondering if you address that in the book, or if any of the panelists could help resolve that tension.
Page 65, it's all there. No, it's not. Yeah, so that's a great question, Jody. And so, as I think, as Nick said, the word animus is not to be found in the Constitution, right? The term class legislation is not to be found in the Constitution, and neither is the word faction, right? So so the term that I'm talking about and the terms on which that term builds, they're all absent from the Constitution. And so what do we do about that? And, there are a couple of answers. And I think the answer of earlier courts, 19th century courts, for example, when thinking about class legislation, was that, we should not feel ourselves bound by something as banal as the actual words, right? I think 19th century courts had a much more expansive understanding of principles that might underlie the actual words in the document. Now, in our age today, we tend to be a little anxious about those sorts of broad statements because we tend to think that they're covers for courts running amok, or that at the very best they're good, well-intentioned, but illegitimate attempts to sort of put in the document what really wasn't there to begin with. So I completely get that's maybe not something that we want to do. But I guess the second answer is to suggest that there are lots of things that are not in the Constitution explicitly that kind of are there by implication. And, I'll just give you an example from Justice O'Connor in an important federalism case. She basically said, federalism is kind of like the air we breathe. We can't see it, but it kind of permeates everything that we do. And I think what permeates everything that we do in the 14th Amendment area, and maybe even more broadly than that, is a commitment to a Republican form of government. And what a Republican form of government really means is it's a government that is literally a res publica, a public thing, a government that is for the public, for the broad public interest, rather than simply for private interests. Now, you have to make a lot of logical leaps in order to get to that point. You have to sort of be willing to find content in the thing that you can't see, right, to use Justice O'Connor's terminology. But I think if you don't do that, then I think we are left with a deeply impoverished understanding of what the Constitution is all about. It just can't be the text only. And I would bet that even a constitutional textualist would say that, because constitutional textualists were all in with the federalism cases from the 1990s, and yet there was not a word about commandeering or any of those other terms that the court utilized. I think you have to do that if we're choosing to expound a constitution, which of course we are. But that's just my own opinion.
I have a question about the future of Animus. I think that legislators are getting a lot better at hiding Animus. So, things like bail algorithms or community preferences in affordable housing lotteries. Will courts be more searching to look for things like that, or will legislators just be better at kind of burying their Animus?
Yeah. Well, look, the hard question is, how do you find Animus when there's no smoking gun, right? When there is a smoking gun, of course it's easy. And let's be clear, smoking guns sometimes do exist. All you need is a Twitter account to find lots of smoking guns nowadays, right? Having said that, James, of course you're absolutely right. It is easier and easier to, cover up Animus under the guise of, and now particularly, technocratic database decision making, right? And I think that's where, frankly, the Arlington Heights discriminatory intent factors really can play a role. Because what are those factors? Well, there are factors like this. To what extent does this challenge law have a really disparate impact on the burdened group? To what extent does this law kind of reflect kind of a deviation from the way we've normally proceeded when making these kinds of laws, or a deviation in terms of the substance of the underlying law? And those kinds of factors are really kind of important. And they're factors that, used wisely, and I understand they're hard to use, used wisely, can in fact maybe cut through the surface, for the surface neutrality of a lot of action. So bail reform, right, or bail algorithms. Well, it just, so what is the impact of the Bail algorithm that we're using on a minority community. Well, it turns out it's really disparate. Wow, gee, who would have thunk, right? Disparate impact with a history of disparate impacts just like that starts you down the road, or starts a court down the road of maybe being a little bit more suspicious. And as I explain in the book, that suspicion doesn't necessarily doom the law, but it does require, I think, the court to turn back to the government and say, you know, you don't get bargain basement or rational basis review now. I kind of need you to explain what's really driving your decision and whether it really fits what you're trying to accomplish. And I think maybe it's that sort of holistic, nuanced inquiry that maybe gets us where we need to go.
Is there anything in the Animus doctrine that deals with perceived government intolerance of intolerant people? You know, so
Yeah.
obviously it touches upon the First Amendment issues.
Yeah.
But, you know, I envision, you know, it seems possible like something like internet could be a public utility that could be fully administered by a government entity, and you have something like a white supremacist group who has their internet revoked or something because they're disseminating, you know, dangerous, hateful speech, and
Yeah.
they, you know, they're seeking this, you know, whatever law or whatever decision was made by the government to revoke that from them,
Yeah.
and they bring a Animus or intermediate,
Sounds like
I
a
don't,
case
you know,
for
I don't
the
really know.
ACLU.
Aside from the First Amendment
Yeah.
issues.
Yeah, no, so you know what, that's a great question. And so I'll answer it, and then I'll end with a fearless prediction about the Masterpiece Bake Shop case. And then everyone up here can say, oh, you're just wrong. Government intolerance of intolerant people, right? So Joel mentioned, I think, during his talk, the idea that Animus may, in fact, be working in both directions in Masterpiece Cake Shop, right? There is at least some level of argument that there's animus against a gay couple that sought to get that cake from the baker, that despite the baker's protestations that he really has nothing against gay people, he kind of sort of did, right? Or at least that's the argument, right? On the other side, in moving in the other direction, there's also the argument that the Colorado Civil Rights Commission was kind of had it in for the baker, and that they were, in fact, intolerant of the baker's own intolerance, and that could itself be seen as a manifestation of animus, right? So this is tough because, and I think the toughness of this question is reflected in Justice Kennedy's Obergefell opinion, the same-sex marriage opinion, where he goes out of his way to say the opponents of same-sex marriage are not, in this case, motivated by anything we would denigrate as animus. They're in fact motivated by very deeply respectable philosophical and religious premises, and we're not saying anything to the contrary, right? I think he had to say that because he did not want to tar those opponents with the brush of bigotry, right? He wanted to see them not as being simply intolerant, right? In other cases where there is in fact straight up intolerance, and in return, society shows its intolerance back, that's really hard. And it's a really interesting question whether whether government should be not just intolerant in the sense of regulating it, but intolerant to the sense of ostracizing and, you know, denigrating anti-democratic forces, right? Again, you know, were there really good people on both sides in Charlottesville? I don't think so. And the question is, you know, what is the proper role of government in expressing the opposite view? That no, there really were good people only on one side, and here's what we're going to do to the other side because we will not tolerate it. And I think that is an actually really, really difficult question. Very quickly, and then I'll get to my fearless prediction. This issue comes up, or came up, and I just happen to remember this. I'm sure it's come up a gazillion times in other different contexts. So in the mid to late 1990s, Algeria, the country, was moving toward democracy, and they were having elections. And it just so happened that one of the leading parties was an anti-democratic party. And so the question really arose, so do we tolerate that? And should we say, no, you only get to play in the, you know, in the democratic sandbox if you adopt the, you know, the rules? Germany had to face this, right, when they banned the neo-Nazi parties after World War II. That's really a tough
existential kind of question, right? Now, let me move to my fearless prediction, my masterpiece cake shop. We have arguably intolerance on both sides, right? Intolerance toward the gay couple and the Civil Rights Commission's intolerance toward the baker. At oral argument, Justice Kennedy, who, oh, gee, guess what? Likely to swing vote. Justice Kennedy seemed really deeply interested in the alleged bias of one of the commissioners, and maybe two of them, on the Colorado Civil Rights Commission, the one that assessed a fine against a baker. I could easily see the court saying the following thing: judgment for the baker on the ground that the Civil Rights Commission's decision against him was tainted by animus against religion, or to use free exercise clause terms, is basically, a singling or outer targeting of the Christian baker's religious beliefs, right, for burdensome treatment. The remedy will be the Civil Rights Commission has to do it all over again without that commissioner in as part of the decision. Everyone wins. The baker wins. Justice Kennedy is able to say, I kept my promise in Obergefell, and I didn't denigrate anti-same-sex marriage beliefs as necessarily bigoted and to be squashed. But then he can turn around and say, but of course, if the Civil Rights Commission reaches the same decision through an untainted process, then there's no problem at all, and the baker can be forced to sell the cake. That's my fearless prediction.
Bill, to what extent do you worry that maybe the sort of more robust form of review you're associating with Animus might have a chilling effect on political discourse? I'm thinking hypothetically,
Yeah.
you're not a government official yet,
Yeah.
you're a political candidate
Yeah.
who's fond of using Twitter, and you might use Twitter to express feelings of fear and disgust
Yeah.
that are later going to be used as evidence to
Yeah.
show animus that motivated government action. Do you worry at all if we sort of think about animus in a more robust way that it might end up having sort of a chilling effect
Be
on,
careful what you say when you
right,
answer that question.
on political discourse by political candidates
Yeah.
or potentially within social movements that are using the initiative process to reform law?
Yeah, I do, sort of. On the other hand, I can't say that I necessarily oppose the German Constitution's decision to impose restrictions on the ability of neo-Nazi parties to be part of the democratic sandbox. Now, if it's not neo-Nazi parties, but it's merely people who think, Muslims should be sent home, or whatever the particular viewpoint happens to be, am I concerned about those people being shut down? Well, I suppose once those people win, and once those people instantiate those views, which they have every right, let's say, to express as a candidate, into law, then I think we've crossed a line. And I think the line is called the Equal Protection Clause, or the Establishment Clause, or whatever. And so am I concerned about the political discourse being chilled? I suppose, although I must say political discourse tends to be pretty hardy, and people's desires to be elected tend to be pretty robust. And so I think people will do it anyway. And in all frankness, not that I'm a political scientist, it seems to have worked last time, and so maybe people will think, I'll do it anyway, because I might win too. Yeah, Luke. Hey. Page 65.
So some of this is addressed, but what happens in cases where there is animus, but there are contemporaneous evidence of good pro-competitive justifications, or at least reasonable
Right.
law. In those cases, which clearly may exist and discussed, if you thought about what kind of standard you apply to evaluating the law.
Yeah, sure.
But for the animus, the law wouldn't have been passed. Is it a preponderance of the evidence, over 50%? If you've thought about maybe how to analyze dueling evidence in these cases.
Great practical lawyerly question, right? How much animus is enough, and how do you find it, and what's the kind of structure for uncovering it, and how do you shift the burdens of proof?
Page 65.
Page 65. Actually, chapter 8. It actually is chapter 8. But what I say in chapter 8 is the following. If you follow the template set forth by the court's discriminatory intent jurisprudence, which I think you should, then here's what you do. You apply the factors that we've been talking about, the Arlington Heights type factors, and you ask whether they show that animus may have been one of the things lurking in the government's decision. Not necessarily the only thing, not necessarily the but-for cause, just one of the things. And if the court finds that, then it's up to the court to turn to the government defendant and say, now you need to prove that what you were doing really was not motivated by the animus that I have found as at least one of the potential motivators of your action. Now, what is the standard? The standard is not strict scrutiny. In my view, the requirement of a compelling government interest, the requirement of narrow tailoring doesn't really have a role to play. Really, what the court should be asking the government is, what is the thing that was really motivating you? And once you convince me that this other, more legitimate thing was really motivating you, I'm not really going to insist that there be strict scrutiny, that there be narrow tailoring, and I'm not really going to insist that what's really motivating you is so awfully important as to be compelling, right? All I want to know is what was really motivating you, and I'm going to look a little more carefully than I normally do when doing bargain basement rational basis review to see whether, in fact, what that true motivation was. That's how you do it.
If I could add one thing, which I think expands on your answer, what you say in Chapter 8 with respect to what Luke and James were both asking, is I think by having this holistic application of the Arlington Heights factors, you're not only giving an answer to what do we do this time, with how many legislators have said this, you're also expanding the time frame. So one of my least favorite cases, which I'm kind of focusing on now, this felon disenfranchisement issue. The 11th Circuit had a challenge to Florida's anti-felon disenfranchisement law, which dates from Reconstruction. And it was a blatant, overt attempt to keep all the electoral power in white hands. It was like, let's convict them all of crimes and then we won't be able to vote. Smoking guns all over the place. So the 11th Circuit gets a challenge that this denial of equal protection is based on intentional discrimination. And the majority says, well, no, it actually isn't, because since then the law has been reenacted by people who didn't say anything like that. Okay, so they kind of laundered the racial discrimination. And I think if you're looking at your Arlington Heights factors, the multiple, it's the same kind of answer that you gave to Luke and James, you can get that out. You're kind of allowing the smoking gun to kind of raise some eyebrows the next time, instead of just saying, well, that's the past.
Yeah, it's a holistic inquiry, and it includes things like, what were you doing yesterday, or 50 years ago, or 100 years ago? Because, of course, that's still relevant to the decision that you've made today, and still relevant to the reasons why you did today what you did today. Absolutely. Yeah, thanks for the amendment. I guess we have time for one more, maybe? Is that, yeah, okay. So maybe one more question, if anyone has one?
Hi, I'm David. I'm from Texas originally, which in terms of animus and smoking guns is like the Wild West. And one in particular was HB2. And the whole women's health in Hellerstedt. I was curious, in terms of you talking about the analysis and use of the doctrine, Elena Kagan, I think in oral argument, was talking a bit about, less about the intent looking into congressional record, but more intent looking into other empirical analyses. So for example, she said, why is it that you would regulate abortion when there are more dangerous procedures, and yet you don't really seem to care about regulating those?
Yeah.
Maybe could you speak to the use of comparing various kinds of more objective empirical analyses and the use of trying to discover animus?
Well, I'm not sure about the empirical stuff, but I think I can respond to your question about the Texas abortion law, HB2. So talk about who we had for con law or who we had in law school. So I had the great pleasure of having Catherine McKinnon for sex equality law. So Catherine McKinnon, if you don't know, is this extraordinarily prominent and important theorist of sex equality law. And she taught me, among many other things, that maybe a mistake was made when Roe versus Wade was decided on a liberty ground rather than on a women's equality ground. And the reason I bring that up is because it seems to me that what you're describing in terms of the dangers of an abortion at an abortion clinic versus the dangers of, an appendectomy at a hospital are such, they're so skewed that when it's the abortion that's being restricted, one might reasonably ask, well, why are you doing this to women? And I think under the Arlington Heights factors, one can easily say, in a world where women's sexuality has been so deeply controlled for many centuries, in a world where this law, gee, what a coincidence, who would have thought, has this deeply disparate impact on women, then maybe we need actually to kind of look at the law a little more carefully and ask whether, in fact, what's really going on here is a sincere concern for women's health. Not that we'll second guess legitimate, sincere scientific judgments. This isn't strict scrutiny land, right? But we really do want to know that what you were really thinking about was women's health rather than controlling women's sexuality, subordinating women, whatever the terminology you want to use. So I think it fits. But I think it fits only if you think, or better, if you use an equality theory, which is, of course, where Animus fits the best.
You should take a last word on whatever you want.
I don't really have a last word. I've kind of said my piece. I guess, this conversation has been really useful, and I really, really mean that. I mean, it's given me some thoughts about where to go next in my thinking and my writing. And I appreciate the challenge to think about the next project, Sabeel, so thank you. But all this conversation really did that. And I'm so delighted that there's this interest in this topic, because like I said at the podium, we may not like that we have to think about it, but we do. So thank you for joining me in that conversation.